So at this time, we want to welcome our next presenter, Mr. Doug Howard.
I'm going to talk about heirs property. If you haven't heard of that term, heirs property, we're going to go over that in just a little bit. But most studies show that I have looked at, what's the number one fear most people have? Speaking in public, believe it or not. And then the second one is dying. So I'm going to speak to you all in the public about dying today, unfortunately. But we're going to talk a little bit about that here. If you all have, it's very informal. We've done this presentation quite a bit. So if you all have any questions as we go along, please don't hesitate to stop me and ask. But let's talk about heirs property. So what is it? We're going to talk about some basic estate planning and succession. And that is going to lead into hopefully ways to prevent heirs property. So let's get right into it. Let's see. So heirs property typically is a family-owned piece of property where it was jointly owned by some individuals who passed away and they did not have a will. And so that property goes down. We'll show you here in just a little bit how it goes down. The typical folks that that are heirs under Kentucky law is going to be a little different than what you might think. And because it did not have because the individual who passed did not have a will, or it did not go through probate, there's going to be a lot of issues that come up, including clear or marketable title. That's going to be a problem. Individuals don't necessarily have good marketable title. And what does happen is fractional ownership. So a few people might have a certain percentage, some others might have a certain percentage. And when you start breaking that out exponentially, you're going to have a lot of different potential heirs. And some heirs that may not even know they have an interest in the property. What also may be a problem, what to do with the property. Not all heirs are going to be in agreement. Some heirs might want to keep it in the family. Some heirs might want to sell it. So hence the term heirs property. If somebody does want to save it in the family, but another heir wants to sell it, they could potentially force a sale. So lots of different issues will crop up. Obviously, the taxes are a big one. At some point in time, the taxes will go up on an auction block in giving somebody else a potential interest in the property itself because of the tax liens. So now you see all kinds of different ways that heirs property crops up and leads to numerous and multiple problems. So where is this affecting, particularly in Kentucky? Well, it definitely affects minority communities disproportionately. It very much affects rural or poorer communities. Out east, there are a lot of heirs property issues. Out west, not as many, but still a pretty good number. And it exponentially gets worse each generation that comes up as an interest in the property. So let's talk a little bit about how to prevent heirs property. And I've got some slides here that we can kind of go over that really definitely explain heirs property. I'm a visual type person, so it definitely helps me. A lot of people don't have wills. I've seen anywhere from 60 to 65% in some places, sometimes more. It doesn't surprise me. A lot of folks that come to me have never had a will, even though they've had children, even though they've been married a couple of different times, or they have a large family. Some folks have never had a will. They just don't think about it. A lot of folks don't get around to it. It's hard dealing with something like this. I understand that. They don't want to necessarily face what happens if and when you pass away. A lot of folks have this second reason: I don't have enough. I don't have much. What I have, they can fight over. Well, turns out that even when you don't have much, people like to fight over very small. Yeah, everybody's shaking their heads because they've known one or two estates that they've fought over the littlest things. So having that attitude is the exact opposite problem for folks to have, unfortunately. So, and you can see the rest of these. We've all probably have heard folks different excuses and whatnot. Well, here's why you should get a will. There's a lot of reasons, one of which obviously we're going to talk about heirs property, but it protects yourself, it protects your family. The attitude, well, I'm going to be gone, they can fight over it, is the absolute worst attitude to have. It gives everybody peace of mind. It lets folks know what your last wishes are, and it's enforceable in court. So it limits and or lessens heirs fighting amongst one another. You might have certain possessions that you want to go to specific people. That gets clarified. And the big one that I think, if you have anybody in here that knows somebody who has children under the age of 18, absolutely has to get a will. Because this is the document that you're going to name a guardian in, and is the document that is enforceable. Otherwise, you're going to leave it to the great Commonwealth of Kentucky to decide what to do with your children or your grandchildren. And I can assure you, you don't want that. And it also streamlines and makes the process much smoother, much easier. A lot of folks think, going through probate's a big problem. But if you've got a will, it really lays the groundwork and makes it a whole lot easier. So a lot of folks say, well, I don't need a will because it'll all just go to my spouse. That's not accurate. If you die and you do not have a will here in the state of Kentucky, the first group of folks that get your estate are your children. If you don't have children when you pass away, it goes to your parents. If you don't have parents when you pass away, it goes to your siblings. If you don't have siblings when you pass away, then it goes to your spouse. And then it goes on out from there. Your spouse is actually fourth in line. Now, there's a caveat to that. Spouse is always entitled to challenge anything and get 50%. So this isn't exactly accurate, but it does illustrate why folks who think, it's just going to go to my spouse, why that's not accurate. So if you do pass away and you have a spouse and children, then 50% goes to your children, 50% go to your spouse, and so on. Now, a lot of folks have asked me, why is that? Well, I can tell you that almost 1 out of 2 situations of clients coming in to see me for estate planning, at least 1 out of 2, they have blended families. There's his, there's hers from previous relationships, and then there's theirs. So that's what the law is trying to address. When you have blended families like this, that's why it goes to children, parents, etc. Another wrinkle that affects heirs property as well, in the state of Kentucky, there's a dower interest. What's a dower interest? Well, there's a long-standing statute that goes way back, probably to the first iteration of this current set of statutes that we've got, that says when you get married, your spouse has an interest in your property. That's about all it says, very simple. One would think it's simple, but it's not, because nobody's ever defined what that interest might be. So what happens is you've got a lot of folks who have to deal with spouses and get their signature on a lot of things. So like I said, I'm a visual type person. I think this is a great illustration. At the top there, you've got the parents, mom and dad, who've passed away. Mom and dad had 5 children. As you can see, 4 out of those 5 children have passed. 1 still alive. Then it goes down to grandchildren, and multiple grandchildren there who are potential heirs because mom and dad unfortunately did not have a will. Now grandchildren have potential ownership to the property. And on down to grandchildren. And as you can see, I don't know if you can see that, hopefully you can see the percentages. So the first top level there for the children, 1 out of 5 is still alive. That means that child has 20% interest in the property. Now you can see why it's fractional, why it continues on down the generations and starts getting smaller and smaller portions. So the grandchildren all potentially have each a different percentage, because they are standing in line for their parents, the child of the parents at the top, they're standing in line for their 20%. So you can see that first all the way to the left here, the first 4 siblings there for the grandchildren all have potentially a 5% interest. Then 2 more grandchildren, they have a 10% interest because they're splitting, the first one's splitting 20%, the second group splitting 20%, and so on. So now all of a sudden you've got 2 layers, 2 different percentages, and it can go on down each generation, getting smaller and smaller, hence the term heirs property. And this is why folks have fractional ownership in some of these pieces of property. Any questions so far? Yes, sir.
So how far, so the one person protesting takes you back to court, is that all of it?
Oh, I think he wants to, I think he's got a microphone there for you. I can just repeat the question. I'm sorry, go ahead.
Okay. You said earlier that any heir could protest.
Correct.
So that goes down to the generation, so one of these 1%ers could protest.
So the question is, could one of the people down here on the very bottom line, the great-grandchildren with only a very small fractional share, 1%, can they force a sale of the property? The short answer is yes. Because the way the court has to deal with it, assuming that we're in court at this point, because eventually everything like this gets into court, that one person can force a sale because the judge doesn't have any other discretion. The judge can only sit there and say, all right, sell it, and we know exactly how much everybody's got. That person can have their 1% and so on. Now, what happens most of the time, if one of these individuals wants to keep it, they try to buy out the other interests. That can get very difficult because maybe that person doesn't have very good credit. Maybe they can't find some of these heirs. I mean, when you get down 4 generations at that point in time, not everybody's local. Not everybody's in the same state, probably. More likely, they're multiple different states. So you're going to have a hard time. And one of the worst ones that I've actually had to deal with, 13 siblings. And we had waivers and or deeds signed from 12. We couldn't get the last 13th sibling in Detroit to sign off on it. That client finally gave up. I don't know whatever happened to it. It's probably still sitting there with 13 potential owners, if not more. I've heard of other scenarios out east where the neighbor continues to pay the taxes on a piece of property that the original owners died approximately 100 years ago. Can you imagine how many heirs there are 100 years later, or potential heirs? There's absolutely no way you're going to be able to find all of those heirs. Now, they were using the property. They were enjoying the property, so they didn't mind. They paid the taxes, and they got to use it. The owners now at this level have no idea. I'd say 99% of them have no idea that they even have a remote interest in Harlan County, Kentucky, of a piece of property. Hence, heirs property. So this is why heirs property gets very convoluted very quickly, a big problem very rapidly, and that is very difficult for most everybody to resolve or solve. Hang on just a second. I think he's got a mic for you. So as you can see, this can be very convoluted very quickly. So the idea of, oh, I don't need a will is absolutely not correct for most everybody. Yes, sir.
When it goes way down the line like that, where does the tax burden go? How does the county or the state collect the taxes, and who pays the taxes?
Very good question. If for those who may not have heard, who takes care of the taxes at that stage? The PVA's office, through the sheriff, sends out taxes, right? If the sheriff and or PVA do not have any new information, they're just going to send it out to John and Jane Smith at the address that they've got. And it could be sitting in their mailbox now. Hopefully their mail is going to one of the children. Let's just say the second line there, the children, all 5 of them are alive. Hopefully one of them is getting that. And at that point in time, whoever's getting the bill probably will take care of it. If they do not, every April in just about every county in Kentucky, tax liens go up for sale. And majority of the tax liens that go up for sale, no matter which county it's in, 90% of them, if not more, are probably going to be bought up by a lot of these tax lien companies. So it's not even going to be owed to somebody local. And then they jack up the price 4 to 5 times. So what was a $500 bill is now $3,000. Eventually, the tax lien holder is going to have to force a sale. Or if there's still a mortgage attached to it and they're not getting paid, the bank will force a sale. Sometimes that's the easiest, cleanest way to clean it up. And then somebody gets probably a really good deal on a piece of property that shouldn't be getting a good deal. But that's a very good question. The short answer is let's hope that one of the heirs is paying it, but they don't have to. So if it doesn't go up on the auction block, a company that's not local is going to probably buy it, and at some point in time within so many years they have to force the sale. So it would at least get back into circulation as a piece of property with marketable title. But let's say that in the case of this piece of property like out in Harlan County, somebody does continue to pay the taxes. The PVA, the sheriff, they don't have any idea. They're never given notice, although I would think that they would hopefully see that John and Jane Smith were alive 100 years ago. That doesn't necessarily mean they will see that or notice that. So if somebody continues making payments on the taxes, it could sit there indefinitely. So, yes, sir.
If somebody forces a sale of those grandkids and I buy the property, do I get a clear title? Or I'm joined with the last 12 people?
If it's going through the court system, more likely than not, you're getting good, clear title. Because hopefully it will extinguish all of these different potential heirs' fractional ownership. However, maybe the foreclosure attorney didn't do it properly if it's going through the court. If it's going through a regular channel, you better hope that the closing attorney has gotten signatures from everybody, because that's where it gets very difficult. If you look at the first line of children there, let's just assume all 5 children are still alive for the purposes of this illustration. Kind of goes to your point. Let's say that 4 of the children are married and 1 is single. How many signatures out of those potential 9 people, right? 4, 5, right? 9 people? How many signatures out of the 5 kids will a person have to get to pass good title? And the answer is they will ask for all 9, the 5 children and the 4 spouses. Now, talking about a dower interest. Let's assume that 5th child is married but going through a very nasty divorce. Do you think that spouse is going to be keen on signing their rights over, whatever rights it may be? you've got another hurdle that you have to overcome. So the short answer is, if you don't have everybody on board and they've signed off whatever right they may have, or it hasn't necessarily gone through court, you may want to make sure you buy title insurance, because that could be a very difficult thing. And anything that has this many fractionals, I would probably advise getting title insurance anyway, because it's just so easy to miss any one of these fractions, any one of these parts, any one of these individuals who could be married if you didn't get their spouse's signature or the closing attorney didn't. So I would, in that scenario, absolutely advise getting title insurance to make sure, because if there's a problem down the line and title was not passed to you correctly, you can go then back against the title insurance, and either they'll have to clean it up somehow or fix it for you through the court system. It gets very convoluted. Hence why heirs property is such a huge problem in minority communities, rural, poorer communities. You get out further east, I think it's Martin County, only 20% of the land in Martin County is owned by individuals. 80% of the real property, the dirt, in Martin County is owned by large corporations because of the mineral rights, coal, and they're based somewhere not in Kentucky. So all that money, if there is any, is going out of state. The 20% that does, 20% of individuals who do own the property, it can be very difficult when one of them passes, oh, I don't need a will, and then you've got this situation. So it gets very complicated very quickly. Let's see. You can disinherit anybody that you want. You would need to leave them out of the will. A lot of folks want to just put somebody in there and say, hey, I'll give them $1. That's fine, but you don't have to. You can absolutely leave anybody out that you want to, except your spouse. If you do try to disinherit your spouse, the spouse can come back against the will and ask for their share. Of course, we mentioned if you pass away and you don't name a guardian for your minor children, you're going to have to deal, your heirs or your loved ones who do want to take the children are going to have to deal with the wonderful state of Kentucky. That is not easy. Make sure you talk to your spouse if you do have young children. Communicate. It's a much harder decision than you think it is. A lot of folks come to me and we sit down, we start planning, we start going over things. I say, hey, what do you want to do about this? Oh, I never thought about that. So then they have to start thinking about it, which spurs a conversation. So make sure that you relay your wishes to everybody that you can. The probate process. A lot of folks, well, I don't want to go through probate. Well, it's not as difficult as it might seem. It can be complicated because of the diagram we were looking at. Fractional ownership can be very, very difficult. Or there are lots of assets spread out all over the place. But it's really not as difficult as people want to make it out to be. You file your petition, that is the document that starts everything, and you file it with the will. That gets the process going. You want to make sure that if there is real estate involved, that you go through probate. You want to make sure that, of course, if the individuals who may be receiving anything, your children, for instance, are minors, you're going to have to go over because there's certain processes that have to be done and certain orders that have to be entered to take care of minors. Obviously, a will certainly limit the disputes between the different heirs. There could be a problem if the will is not well written. For instance, I leave everything to my children. Okay. Well, with your current spouse, you have 2 children. Unbeknownst to current spouse, you have an older child. I'm dealing with that situation right now in Oldham County. It just says to my children. They noticed the two that they knew about, and I'm representing the third, who should stand in line because the will does not specify. It just says to my children. So even what seems to be a very simple, innocuous way to divide everything all of a sudden becomes complicated. His, hers, theirs, blended families, a lot of folks have all kinds of different scenarios like that. What do you need in your will? Aside from how you're going to distribute everything, you need to name an executor. The executor is who's going to actually show up in court, take care of everything. That individual has certain powers, certain rights to move assets around, sell things, sell property, real property. If you're going to name somebody, you might want to just give them a heads up. Typically, if you're married, your spouse is going to be first. At some point in time, when both spouses pass, then you need to have a backup. I would talk to that backup before, and most of the time it's going to be a child over 18 of the individuals. But assuming that's not the case, let's say you pass and neither of you have children, then of course you're going to have to choose somebody else. Going through that situation right now, trying to figure that out. So talk to your executor or potential executor. I always try to bring up contingencies, have a primary and a backup. Yes, sir. I'm sorry? The question is, do you have to list an executor in the will? Yes. Yes, absolutely. That just makes it a whole lot easier. Most anybody who's going to put together a will are going to make sure that they list an executor. And I would list a primary executor and a backup too. It's a question, if there's not an executor,
Or it's,
okay. So the question was, if there's no executor, is the will valid? Yes. The will can still be valid, and multiple individuals could then potentially ask to be appointed as executor. Whoever stands in line next would probably ask to be executor. Probably one of the heirs. There's a process for appointing what's called a public administrator, who is typically a attorney that's practicing in front of that court. Just about every county has somebody that they typically refer to, and that person would then have the ability to move things around and sell. If for some reason you should pass and you don't have children or somebody else that you want to provide this to, think about an entity that you can donate to that's going to be around for a while. Church, you're a university, Kentucky State, a charity, your favorite charity, something along those lines. Those institutions are not going anywhere, and I can assure you they love to be named in wills. Absolutely. Most big institutions, a lot of colleges and whatnot, they have somebody who does nothing but goes around and gives presentation on leaving the school or what have you in somebody's will. So, jumped ahead just a little bit, but here I hereby leave my property to my children. There's different kinds of property. When you say property, most people think of real estate. But a car is personal property. Mobile home is personal property. Your items in your house are personal. And so on and so forth. So all of a sudden, just the word property can bring up a problem, including children. Again, our previous illustration. If you know how you want your real estate divided, This is the document to be as specific as possible. Specificity is much better than generality. So a lot of folks say, well, what do I need to do here? I said, well, if you've got a specific way you want everything handled, or a specific item that is supposed to go to a specific person, this is the document you put it in. Otherwise, there's multiple ways of dividing. Let's just take a farm, for instance. It's multi-acre. Everybody, let's say it's a 20-acre farm. There's 4 individuals, so they get 5 acres each. But it's not like a big square. You can't just cut it twice down the middle and everybody have their own. Maybe one is better for farmland. Maybe one has got a lake on it and somebody likes to fish. Maybe one has the house, and maybe one is the side of a hill with a lot of timber. You can't just simply divide it up and give it out to your individual heirs. If you want to do something like that and you can subdivide it, do it while you're alive. That way you can get absolute surety of how it should be divided and what piece or portion everybody would get. Yes, sir. What about in the case of I didn't hear that. Okay.
A half-sibling?
So the question is, what if an individual has a half-sibling? Then if the individual, the parent that they share in common that passed away, then they are equal shares. If it's the parent they don't have in common, so one's a step-parent, the half-sibling does not stand in line for anything. The statute only recognizes specifically the children of that decedent. But that's a good question. Instead of physically dividing the property, maybe you financially divide the property. Maybe this 5 acres over here is just as good as this 10 acres over here, and this 1 acre here, etc. So maybe you can divide it that way. There's all kinds of different ways to think about this. And so these are the type of things that you want to address when you go in, and you want to try to be able to avoid certain issues popping up like heirs property. Typically, an individual is going to pay their debts out of their assets, out of their estate. A lot of folks ask me, well, am I personally liable for my father's debts? Personally, no. But if there are assets that are in the estate, then the court's going to make you liquidate to pay off creditors, including mortgages or judgments. Maybe somebody has a credit card that they are due and owing. Those are all potential valid debts, which do have to be paid out of the estate. And it also goes back to the heirs having fractional ownerships. If you have a farm in your family, that might be something to think about. Who do you appoint to take over the farm? Maybe your children don't want to take over it. If somebody asked me to do something, I would have not one clue, the first clue as to how to operate a farm. So if you do have a working farm, as an illustration, maybe you need to figure out how you want that to be handled. Yes, sir. So the question is, is a tractor personal property? Yes. Yeah, so real property is just about anything that is either a building or actual dirt. Just about everything else is personal. So, good question. So when you go to sell a piece of property, including an heir's property, the first thing that most attorneys do, if not all attorneys that are going through that, are going to do a title search. Chain of title is very, very, very important. And what I mean by chain of title is, if you look at your deed to your piece of property right now, it references the previous owner. So you can go find that deed. And when you pull that deed references the owner before that. Hence the chain of title back all the way to most counties that have land grants. Franklin County was a land grant. I have found several actual grants right around the completion of the Revolutionary War for about 5 of my ancestors who got land grants as payment from the war. So you can go all the way back in some counties to that actual land grant. But that's the chain of title. And hence why heirs property affects that chain of title. Because if you break that chain any which way in any one of those links, it creates a huge problem. Why it's an incredibly large problem for heirs property because, again, fractional ownership. So an individual or an attorney who's doing the title search is going to try to track that down. They're going to see an estate typically, or they find out that the person's passed away. Then they're going to check for an estate. Hopefully an estate has been filed and all the proper documents are in place. If you have a will and that goes through probate, it gets recorded at the county courthouse. And it's one of the only documents that they actually have to keep the original by statute. A lot of folks ask me, well, am I going to get the will back? I'm like, well, no, we'll get a recorded copy, but we can't get the original. Unfortunately, by statute, they keep them. If you go over Lexington right now, and if they would let you, Henry Clay's original will is still on file. That's how far back their records go. So, if any one of the links in a title have a problem, hence the heirs property. And you've got to start tracking everybody down. There's also different ways to own property. There's joint tenants in common. That is typically where 2 individuals or possibly more own a piece of property jointly. And in the body of the deed, it does say somewhere like to the survivor or rights of survivorship. That means the person, the first person who passes, their interest immediately goes over to the other person. Then you can also have just what are called tenants in common, and you're going to see that, well, the diagram that we had, those are all tenants in common because they own potential different amounts. And you would typically see this type of arrangement for a deed in sometimes siblings, of course, but a lot of investors. If there's multiple investors on a piece of property, that way each person can own a separate percentage. But it also is how heirs property is presenting such a large problem. The deed has to have a legal description, and that is often in some counties, start at the rock, go to the creek, go to the oak tree, come back around to the fence, etc. Those are still valid, and some people actually know how to find all those landmarks, but obviously landmarks change. Trees get cut down. It can be very difficult. Most of the ones that you're seeing now, modern deeds, just refer to lot number 1 on plat A, slide number 25. Those are recorded documents in the county clerk's office that anybody can go pull, and you can find your lot on there, and it has all the meets and bounds and where the pins are, etc. The other way, you can actually put all the meets and bounds, indoor pins and whatnot, into the actual body of the deed, but most of the time they just say, see lot 1, plat 5, etc. Person who is going back and doing the title search obviously is going to look at tax status most of the time. That can be a huge problem because you can't convey marketable title if, like, the 2020 taxes are still due and owing. So they're going to go back and find those type of things. They're also going to look for judgment liens. Any sort of encumbrance that is attached to the property. All of those have to get cleared up. And so when you've got heirs property and you go down a couple of generations and child number 8 or grandchild number 8 has a bunch of judgment liens against her or him, those all could potentially be issues attached to that piece of property, which have to be cleared up somehow. That's why just about every title that's done, there are quite, a few attorneys in whatever county that do it, and I highly recommend that. Or get a title company. There are certain title companies that do that as well. You can transfer title by deed, but you can also transfer by will. That's why a will is important, because it does get recorded, and when it gets recorded, it becomes part of that chain of title. It becomes part of it so that whoever is doing the chain of title search down the line, oh, okay, John Doe died in 2000, Jane Doe is still alive, but they can track that down because the will is recorded. Hence another reason why a will is important. It clears up so many, it's a very simple item that clears up so many problems, potential problems down the line. Now, of course, a deed takes precedence over the will, but typically if there is a will that's recorded and the person has passed away, that is valid to show that the property has gone over to the heirs. Yes, sir.
The last line there says conveying title by transfer on death deed in some states. Is Kentucky one of those?
No. No, the question was, does Kentucky allow transfer on death? For deeds, no. You definitely have to have some sort of probate to show how it was disposed of and or who the heirs are. It is not automatically. Now, the rights of survivorship is somewhat a form of that, and so Kentucky does have that. But typically what they're talking about here is it authorizes a wholesale transfer without having to go through court in some states from mom and dad to child or whoever it is. So that's as you can see, these slides were prepared for heirs presentation in multiple states. So, or some of these are my slides, and some of them are the ones we've kind of put together. Was there another question back there? So we've kind of gone over some of the issues that pop up, some of the issues that come up. Goes back to the diagram. I can see this a whole lot easier. It's a great illustration for me, so I think it's very helpful. But now you see why all of these different fractional ownerships cause such a huge problem on the chain of title. Hence the term heirs property. Kentucky does not have, there is a model statute that certain states, not very many, have adopted, but more and more are trying to be adopted. And Kentucky is not one of those. It does provide a way to try to clean up some of this so that people don't lose the property, that doesn't get forced to a sale, so that somebody who does want to keep it in the family can. So if you know your legislator, and you can talk to them about that. We've been encouraging folks to do that. It is a very difficult problem that doesn't really affect as many people as you might think. However, certain counties, it can affect a very substantial. Certain counties, it's anywhere from 15 to 20% of the property that is on the books has some sort of heirs property component. So 1 out of 5, 1 out of 6 in those particular counties, and you probably can guess they're over in eastern Kentucky and a couple in western Kentucky. 1 out of 6 1 out of 6 pieces of property have potential problems because of heirs property. So in certain communities, that's a pretty big number. It could equal thousands of property depending on the size of the county. But as you can see, when you start funneling down, oh, I don't need a will. So John and Jane Doe at the top, oh, I don't need a will. Their kids. Sibling number 2 is the only one alive. The other says, oh, I don't need a will. So it passes on down, so on and so forth. So when you do get started, when you start getting down into generations even below this, which is possible, you get 0.01 fractional shares or what have you. So it can be very, very difficult. We'll go over very briefly just some other mechanisms for property. You can create a living trust. A trust is an entity that is created that can own property. Living trust just means obviously it was created while the individual is still alive. And if you are going to think about doing a living trust, there are certain things that are very much give you a lot of protection when you go and put it into a trust. So there could be quite a few reasons why you might want to look at that. If you do look at that, then you need to create the trust. You have to pick a trustee. A lot of times it's going to be the initial grantors, the people who set it up. They will be the initial trustees. You have to pick somebody who's going to take over when they can't do it. So something to think about if you're going to set up a trust, who's going to take over when you pass away. That trustee has what's called a fiduciary duty. They have to make sure that they take care of the property that is in the best interest for the beneficiaries. They can't go to Belterra and put everything on Black 22. That's not a good idea. But living trusts can own property. They file tax returns. It provides, in certain cases, tax shelters. So could be quite a few different reasons why you might want to talk about creating a living trust. And a living trust would take care of heirs property issues as well, because what happens on a living trust, you name beneficiaries. Most of the time, it's going to be your children. It doesn't have to be. It can be other individuals, but it will list those individuals as beneficiaries. And then it will tell or state what those beneficiaries are receiving. So it operates at that point like a will in terms of it divides up the property, make sure it gets to the right place. Just some other documents to think about when if and when you need to go do some estate planning. Living wills, I always highly recommend anyone to get those. Those are your end-of-life wishes if you're hooked up to life support. You can direct if you want the life support to be removed or to remain on life support, or withdraw artificial nourishment. Very important. It's not easy to think about. It's not easy to contemplate, but it is extremely important, and I highly recommend getting that. We don't charge any. If anybody wants to come down and get just a living will, we wouldn't charge anybody for that. On a living will, you have to pick the surrogate. The surrogate is the individual that's going to be the person that the doctor comes talk with if the principal is incapacitated and or hooked up to machine, and the machine is the only thing keeping them alive, then the doctor will go out, talk to your surrogate. Again, if you're married, your spouse is typically your first and foremost individual surrogate, but choose a backup. You can authorize your surrogate to make the choice of whether or not to remove life support. If you do decide to do that, please, 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 again, communicate. Make sure there is absolutely no question what your wishes are as far as if you're hooked up to life support. Another document you might want to consider, power of attorney. This is a document that authorizes another person to act on your behalf, whether it's financial, whether it's medical, certain medical, filling in forms, writing checks, closing accounts. They're pretty broad, and they can give an individual the authority to operate on your behalf. Yes?
How long does that last? As long as the person lives, or does it in a short period of time?
So the question is, how long does a power of attorney last? The answer is yes to both of those. So you can have the general type of power of attorney is open-ended, and it only is null and void upon death, meaning that individual can operate as your authority up and until you pass away, or you revoke it. You can revoke a power of attorney at any time. The other is typically a limited power of attorney, and it is usually for a limited purpose. So once that purpose is finished, then it's null and void, or it's limited in time. So once let's just say it's 1 year from the date of signing, when that 1 year is extinguished, then the power of attorney becomes null and void. So you want to make sure which one you're signing. Again, the agent who is appointed has a fiduciary duty to operate in the principal's best behalf. They do have certain powers to take care of different items. They can pay debts, collect debts, buy and sell property. And most of the time, when you sign a power of attorney, that document is live as soon as you sign it, meaning that person has authority as soon as the ink's dry. A lot of people don't realize that. Oh, and they ask me, oh, well, this only takes place if I become incapacitated. No, it's good as soon as you sign it. Now, there is a mechanism called a springing power of attorney that can leap into action, so to speak, when you become incapacitated. I do not recommend it because it's hard to define incapacitation. The generally accepted definition is upon two physicians agreeing that this individual is incapacitated. Finding two physicians to say that is not easy as well. So I don't recommend it. In other words, be very careful on who you want to select as a power of attorney. Because they still have to operate in your best interest. So again, yes, revocation of power of attorney happens upon death or a certain period of time. A lot of folks come in and ask me, well, what do I do with my documents? Legal documents like this should be kept with wherever you put your mortgages, your insurance policy, etc. Yes, sir.
Go back 2 slides and
I think. That one? No problem. Absolutely not a problem. So keep your legal documents like your will, your power of attorney, your living will, wherever you keep your other legal papers, mortgages, deeds. Preferably that's someplace like a fire safe at your house. A bank box, a safety deposit box is absolutely fine. A lot of folks come to me and say, well, if I do that, can my heir, once I pass away, get access to it? The answer is yes, they will get access. It might not be immediate access. Most of the time we have to go and get a court order or the order appointing an individual as executor to be able to access it. But most courts will enter that so that the individual can go get it. Absolutely. Absolutely recommend that. If you do have a living will, anytime that you're going to go in for a procedure at the hospital, they're almost always going to ask you, do you have a living will? If you do, take it with you, give them a copy. They'll put a copy on file so that it goes part of your chart. You might want to give it to some other folks so that they know what your wishes are as well. And it's something that I would recommend that you update fairly regularly. I've got a few more to go through. My understanding is I was supposed to be finished about now. I don't know what time or how much time. That's not a problem. I can keep going. Well, I had down from Irma that I was supposed to start at 1:30, or actually I was supposed to start after 1:30, but so I apologize if I got the wrong memo. I'm sorry if you all were waiting for me. So, benefits to working with an attorney, particularly in this area, we hopefully will address all these issues right away in some of these documents. These are the questions that I will particularly ask. I'll sit down with you and go through your estate options, what you want to do, how you want to do it, who do you want to get your assets. All of these questions are typically questions that do come up in our planning session for what we need to do. So hopefully, my goal is to make sure that we don't run into a problem where heirs are fighting in court. Outside of child custody, probate court is the absolute second worst. And people, most of the time siblings, with years-long rivalries or problems, will fight over the smallest, littlest thing. My job is to hopefully limit that. I can't limit it in every single instance. It's just not workable with some families, but I will try my best. If you do go to see an attorney and you want to kind of get a better idea of what that attorney does or doesn't do, you can ask them various questions and kind of interview them a little bit. There are a lot of attorneys out there. Some attorneys concentrate in certain areas and some don't. So it doesn't hurt if you say, how much of this type of practice do you do? How much of this type of issue is part of your practice? I generally consider myself a Main Street attorney, meaning that if you come to me for a general problem, I should be able to fix it. Most of the time that is divorce, estate planning, some sort of criminal issue, etc. So those kind of my big three areas that I do. We do a lot of estate planning. We usually run a special in the middle of summer for $99 per person, and that has gone, we've done that about 10 years now. So if you're wondering how much does a typical estate plan cost, you can at least come to us for a simple will, $99 per person. So there are a lot of different attorneys out there, and prices can range pretty significantly between all those. You might need to ask them, are there any potential conflicts of interest? We would try to run a conflicts check at that point and let you know. Generally, we're not going to run into some sort of problem, but it's certainly possible. If you're coming to me to talk about specific estate documents, we will almost always schedule you about a week or two out to come back in and sign the documents. So we try to make sure that our documents are ready in about a week, give or take, at least on estate planning. But it doesn't hurt to say, how long will this take? They can give you a timeline. Most of the time I can give you a potential timeline if it's a divorce, something like that. And keeping informed of progress. That's probably one of the hardest things that I know I do. It's hard to pick up the phone sometimes and make a phone call when you're bombarded with all kinds of different ways of communication now. I tell folks most of the time I will try to respond to an email as fast as possible. Phone call's not as easy. Sometimes I'm in court. Sometimes I'm at presentations, so on. But your attorney should be able to keep you in the loop as to what's going on and or whatever stage we are at for your particular case. And again, ask them, can you give me an estimate of how much this is going to cost me? Sometimes that's very difficult. Sometimes it's very hard to say, yeah, this is going to be a very limited type of case, so it's going to be X. Some cases it depends on how many hearings we're going to have, et cetera. But for the purposes of estate planning, we are pretty consistent with our prices, particularly on a will, living will, power of attorney package. So it doesn't hurt to certainly ask them. You can shop around. Like I said, different attorneys charge different things, and it's going to be a pretty broad range. This happens pretty frequently. Somebody comes in to me and says, hey, I've got this speeding ticket. Okay, let's see the speeding ticket. Oh, I left that at home. If you're going to talk to an attorney about a specific item, take that item with you. Take the deed, take the speeding ticket, whatever it is. If you've got planned documents that you've already prepared or an older will that you've prepared, absolutely bring that in. It is absolutely a waste of everybody's time if you come in, I need to see X, oh, I left that at home, I didn't think we would need it. Better to have it and not need it and vice versa. Some of these other documents you might want to bring in. It is helpful for estate planning purposes if you want to give me a list of where to find people. I will certainly put that in the file. It is not necessary, but it's certainly helpful. Speaking of that, a lot of times individuals say, well, how do I let my loved one know where my assets are? Wherever you keep your will and other important documents, I would keep in there kind of a roadmap, if you will. I have these assets, I have these accounts, here are the account numbers, here are the bank addresses. We're dealing with one right now, an estate that I'm up to 6 different banks with 6 different, well, multiple accounts at each bank. And I haven't gotten to all of them yet. So it is very helpful if you can prepare that type of roadmap. Now, keep it with the document. Don't keep it part of the document. I had an individual who we needed to do their will. We probated the will. I filed the will. I did not realize the last page were Social Security numbers, account numbers, and multiple. Now that's on me, but it shouldn't be part of the will because you don't want that to be recorded in the county clerk's office. Now we were able to go back and clean it up, but that was certainly my mistake. And if something like that happens, we'll certainly try to correct it. If you're going to be talking about business, then you might want your tax returns, profit and loss, balance sheets, those type of items are very handy, definitely helpful. Any list of written agreements, oral agreements, maybe not so much as enforceable, but something to think about. If you have a prenup and we need to go through a divorce, that's something that I need to see. That does happen. And any sort of item that designates a beneficiary. Now what that means is the life insurance policy, most of the time that's the general concept of what is going to be addressed, and you need to make sure that whoever you want to get the proceeds from that policy is actually named in the policy. When folks come in and they don't bring it, I tell them, well, it's a good time to go home, pull out that policy. You might be surprised of who is actually still listed. They do. Sometimes they come back and say, yeah, my spouse from 20 years ago, whom I'm not married to anymore, is on there. That could be an issue. If you can designate a beneficiary on a life insurance policy, certain like certificates of deposit, 401k, IRAs, stocks, bonds, mutual funds, those type of items, if you can designate a beneficiary, go ahead and do that. If you don't, it's automatically going to go to the estate, which could be okay. Some people like that or prefer that. Some don't. Because on a beneficiary who's listed like that, they're going to get their check pretty quickly, and it's going to go straight to the person. Most of the time without having to deal with taxes. So they get it faster, they get it sooner, and typically without having to worry about taxes at that point. Of course, any prior documentation is definitely needed. Because a lot of folks will bring in their wills and we'll go through it and say, well, and there's nothing wrong with this one. It's dated, but there's nothing wrong with it. And I'll tell them there's no need for a new one. Any other questions? Yes, sir.
Could you talk a little bit about revocable and irrevocable trust?
Sure. So the question is, what's the difference between a revocable and an irrevocable trust? Aside from what it sounds like, one's revocable, one's not, they can be used for different purposes. The general living trust is going to be what's called a revocable trust, meaning you are the person who set it up, you are the trustee of the trust itself, you have the ability to revoke it, you have the ability to amend it, you have the ability to move assets around a lot more freely, move assets in, move assets out. A lot of individuals like that because you've got the most amount of flexibility with the most amount of protection that you're going to be able to get from an entity like a trust. Irrevocable trust, as it sounds like, is irrevocable. That is only going to be used in certain scenarios. Now, if you get to a point where you need a revocable trust, I'll get that in a second. It is typically used in certain situations where a lot of times it's going to be a special needs type of trust. Special needs type of trust is for an individual typically who has special needs and is going to require care for the rest of their life. Once you set up the irrevocable trust, it's exactly what it sounds like. You cannot revoke it. You are not the initial trustee. You can be the grantor or the settlor, which means that you can be the person who set it up, but you can't be the one to be the trustee. And that is for the benefit often of somebody else, like a special needs trust or potentially what's called a Medicaid qualifying income trust. If you have certain amount of assets or a certain amount of income over the Medicaid limit, you can set up this type of irrevocable trust and be qualified for Medicaid and still be able to receive those benefits. There are a couple other reasons why you might want one or the other. If you are coming to me and there's a his, hers, and ours type of situation, we can set up an irrevocable trust at the beginning. That locks everything in, so you know if you're the first one to pass, your assets are still going to be distributed accordingly. Because if your wills just say to my spouse first, and you have a his, hers, or ours type of situation, the second spouse often can change things around or change the order of what their heirs are going to look like. So if that's something that you're worried about, an irrevocable trust is a good vehicle to make sure that doesn't happen. There's also a couple of different ways to set up or a couple other reasons to set up irrevocable trust. If you're looking at having to go in a nursing home, potentially have to obtain and/or qualify for Medicaid. Some folks want to try to look at that, and there are some mechanisms that we can do to try to protect those assets from Medicaid. But keep in mind, for most intents and purposes, Medicaid has what's called a 5-year look-back period. So if somebody comes to me, hey, I'm going into a Medicaid nursing facility next week, I want to keep my family home in my family, can we do this? Probably not, because of the 5-year look-back period, which means if we transferred it today, Medicaid has an opportunity to take a look at it 5 years from today. And basically what would happen is they would say, let's say it's a $100,000 house, transferred within that 5-year period. They would simply say, you're not eligible for the first $100,000 worth of benefits. So it can be, definitely want to make sure you look at it. It can be a very good vehicle for certain situations, and it also gives individuals a lot of different protections from other outside entities coming forward and trying to tag your money or go after your money. So, yes.
If you put a farm on a revocable trust,
Mm-hmm.
what does that do to the tax implications?
So most trusts are going to be reported as a schedule attached to your regular income tax return. And typically, it's not, for most individuals, it's not going to be affecting the tax insofar that the property tax is going to be the same. If it does earn income, it has to report that income and have to pay for it. There are certain tax shelters that can be put into trusts. If you are at that level and want to look at tax shelters, I recommend you go to see somebody who does that on a regular basis, because I don't know enough to keep up with all the ins and outs for the tax shelters. But there are mechanisms that can be used to give you tax benefits and or making sure that people down the line and your descendants have ability. Oh, okay, yes. So the question is, if I transfer my farm now, what's the value going to be? And typically, for the purposes of transferring to the trust, it's going to be today's value, which can make a big difference, because a lot of times when you sell, I've got this situation, the individual paid $30,000, and it looks like we're going to have to pay taxes on that $30,000 to today's money. Well, in this particular instance, we're just going to have to pay the tax, I think. Now, when you transfer it into the trust, yes, it should be at what's called the step-up value, meaning today's value, so that whoever is going to be the beneficiary of the trust and receive that property down the line shouldn't have to pay capital gains tax on that. Or it would lessen, I guess I should say, lessen capital gains tax.
But then, will there be capital gains that goes down to the trust? Is that, whoever's put it in the trust, they're going to have to pay capital gains?
They shouldn't, no. Once it goes into the trust, then it sits there in the trust at that particular valuation until it gets transferred out. A lot of revocable trusts are going to set 1, maybe 2 layers of beneficiaries. A lot of times it'll be extinguished after that. So the government realizes at some point that property's coming out. So it'll get tagged at that point. But it should come out at the higher stepped up basis. And so the capital gains should be calculated on a much smaller scale.
So if you bought it for 50, it's worth $1 million, that 50,000 is worth $1 million now, you go into the trust, and that's the basis of
It should go in the trust at that basis, correct. Now, this is where I say contact an accountant, and if they tell you different, go with theirs. because I'm definitely not an accountant. Yes, sir.
If you had your farm in irrevocable trust, while you're still alive, who's paying taxes? Do I still have power over it?
So the question is, if the farm is transferred into a trust, who's paying the taxes? The simple answer is you set up an account where your income goes into the account of the trust, and those funds come out and are utilized for the payment of those taxes. So essentially, nothing changes except where the money's going in and the account the money's coming out. It still gets paid. It still gets paid out of basically your money, that's your income, but it just changes checking accounts essentially. Instead of your personal checking account, it's the trust account. Some clients like to have a trust account and then their own account as well. A lot of folks just feel comfortable with that, which is absolutely fine, not a problem. And that's something that we can certainly talk about. But my general advice is put everything you can into the trust, put as much money and assets that you can in the trust, because that way you're getting the full benefit. Either one. Now, keep in mind, any asset transferred into the irrevocable is locked in. Yeah, it's locked in for the benefit of the beneficiary. It can't be changed. So if you have property, typically my advice was probably not transfer that property, that real estate, into the irrevocable trust just yet. We can do that with what's called a pour-over will. And that's just a will that's a kind of a catch-all. Basically says anything that's not transferred into the trust now transfers into the trust. And at that point in time, it would lock in. Now, often I think under irrevocable trust, I'll have to go back and look, the trustee on down the line, if they need to sell the property for the benefit of the beneficiary, I think they do have that option, but that'd be down the line probably. Are we about ready to wrap up? All right, one more question.
If you have it in a trust, nobody can put a lien on it anymore?
So the question is, if your property goes into a trust, can a lien be put on it? It is outside of your name. So if a lien, let's say a credit card company comes after you and gets a judgment and puts a lien, it would be against you only. So it would not go against the property that's in the trust.
But the trust, you put it to somebody named X. Can they put, he got in trouble with X, can they put a lien on that property?
I see. So if the question is one of the beneficiaries has a problem, can they put against? And the short answer is typically no. Same scenario. It would just be in their name, and usually there's clauses specifically in the trust that say that a beneficiary can't take out a loan against their future earnings or future benefits, et cetera. So that's how that would work. Well, I do apologize. I must have written down the wrong time, but I appreciate everybody's attention, and thank you very much.
I can say I think we have enjoyed listening to Mr. Howard, some valuable information, and I can appreciate that being an extension. Looking back when I first started, probably the most valuable topic that you can cover in agriculture. Thank you again. Let's give him another hand. Well, this concludes the program. Drive home safe. Thank you.